Case set on the 2:30 docket is 22 CA 581 Dakota Ridge RV, no, sorry, we just did that one. 22-749 Fresquez versus Santa Fe Trail Ranch Property Owners Association. It would help visually if I marked off my cases. Counsel, were you present when I read my opening remarks from the last hearing, or do you need me to repeat them?
I was, Your Honor. Yes, Your Honor.
All right, then I won't repeat them. If there are no questions, we will just dive right in. Counsel?
May it please the court. My name is Daniel Miller, registration number 49421. I represent the plaintiffs in this case, who are property owners of the common interest community known as the Santa Fe Trail Ranch, located in Los Animas County, very close to the New Mexico border. Your Honors, when people move into a neighborhood, a residential neighborhood, they reasonably expect to be able to use the roads within that neighborhood. Unfortunately, in this case, my clients were denied that basic right which was afforded to them by the Declaration of Covenants governing the community. The Plaintiffs' Property Owners Association, one of the defendants in this case, adopted a rule that permanently closed within the community a certain road known as the Exit 2 road.
Can I get a clarification? There seems to be some confusion on the record, at least to me. When I look at the map, I can't quite tell. The defense motion for summary judgment said that the fence, or the gate, was on the property line. Is it, or is it inside the property?
It's inside the property, to answer your question succinctly, Your Honor. The property line is an infinitesimally narrow line. The gate itself is, I think, approximately a half foot to a foot wide, and it's slightly onto the property of Ms. Fresquez, which is lot G17.
So maybe 2 feet of the roadway is prevented from being used?
No, Your Honor, not at all. The gate physically barricades the last 2 feet of roadway as you get to the edge of the ranch's overall borders. However, the Property Owners Association adopted a rule that states that no owners are permitted to go on that stretch of road in its entirety, regardless of the gate.
On the entire stretch of road?
Correct. The entire stretch of the Exit 2 road as it exists from Alpine Meadows Drive to the edge of the ranch.
And how much roadway is that, rough estimate?
Well, lot G17 is 35 acres, so it's a stretch of crossing a 35-acre parcel.
So you're saying that the rule adopted by the board prohibits not only exiting the property at the gate, but also any use, like from one house to another, on Road 2?
Correct, Your Honor. When the POA adopted its rule, it said that it was going to permanently close the Exit 2 road. The Exit 2 road goes from Alpine Meadows Drive to the border of the community. And it said permanently closed, so no use whatsoever is permitted on that entire stretch of road.
Is Ms. Fresquez able to get to her home?
Ms. Fresquez is able to get to her home. I don't believe that Ms. Fresquez needs to use the Exit 2 road to get to and from the actual driveway. As Ms. Fresquez, as the other plaintiffs and all other owners, are still able to gain access to their abodes via the Exit 6 entrance to the community. This is a large community with approximately 450 parcels, each of it being at least 35 acres. So there are 2 entrances to the entire community traditionally, one at Exit 2 of Interstate Highway 25 and one at Exit 6. So it takes an additional, I think it's in the record, but I think it's like 15 to 20 minutes additional time for them to get to and from their own homes because of the closure of the Exit 2 road.
But even if the gate were removed, the railroad is now gated off the property, so people aren't able to get to the highway through that exit anymore, are they?
There is a gate, so the Exit 2 road continues, once it reaches the end of lot G17, it does continue onto property that is controlled by the BNSF. In my mind, the gate is kind of a more or less a non-issue, because regardless of whether the POA has erected a gate on lot G17, they adopted a rule that says none of you are allowed to go on that.
I was actually, you just phrased it in the other side of the coin. I was going to ask you, if all this was the gate, and there was no rule that said you can't drive on this however many 100-foot section of road, would you be here?
We would. because the POA has adopted a rule that the owners are not allowed to use that, and they have the
That's
power.
what I'm saying. If the rule wasn't, you can't drive anywhere on this road, but they just put up a gate on the property line or very close to the property line because the railroad has gated their part of it, or for whatever reason, you would not be, no owner would be restricted from using any of the roads within the development, right?
That hypothetical is very similar to what existed before the POA adopted its permanent rule closing. There was a gate, but my clients and others had the ability to get in and out of the gate, and you're absolutely correct. My clients did not bring this action until such time that the POA adopted a rule that permanently closed that stretch, irrespective of whether there's a gate.
So if what I'm trying to say is, if the POA said, you can drive up to the gate, you just can't drive through it, would that be a restriction of the common areas?
Technically, yes. Would it warrant a lawsuit by my clients? I'd speculate probably not. My clients are looking for the unfettered use of that roadway so that they can use it all the way to the edge of the community.
The way I read the declaration, your clients have perhaps two independent rights to use the road. One is a grant of an easement, and the other is the right to use common areas, of which the road is one. Are you claiming under both of those provisions, or is it just the common area provision?
Well, I think that the crux of it, Your Honor, is Section 2.2, which is the specific provision that says that the owners shall have an easement right over the common areas for purposes of ingress and egress. So that is the crux of the interpretation of the declaration right there. Now, that's not an absolute right. It is subject to the provisions of Section 2.1, which I can discuss in a little bit. But I don't think that there's two separate rights. I think that the right to use the common areas and the easement on the common areas are essentially one and the same, subject to the provisions of 2.1. Your Honors, what happened in this case is that when the plaintiffs sought to vindicate their rights, the trial court rejected their challenge. The trial court interpreted as a matter of law that the association had authority under Section 2.14 to adopt a rule that would permanently close not just the exit 2 road, but any road within the community. This is despite the clear provisions of Section 2.2, which provide that the owners do have a right to use the common areas, which is undisputedly includes the roads within the community, for purposes of ingress and egress. So there's two main points I want to focus on today, because I do believe that the parties' briefs thoroughly address the issues. The first point is that the trial court erred in granting summary judgment because the plaintiffs offered an interpretation of the Declaration of Covenants under which the association has authority to adopt reasonable rules and regulations for use of the common areas, but does not have the power to permanently close any or all roads within the community. And that interpretation is a reasonable one. As such, either the plaintiffs were entitled to summary judgment because their interpretation was the only reasonable interpretation, or alternatively, if the trial court's interpretation were reasonable, as was the plaintiffs, then the declaration would be ambiguous because it would be susceptible to more than one reasonable meaning, and the trial court was not permitted to enter summary judgment.
What if the interpretation is the court, or the POA is able to pass reasonable regulations? That's the interpretation. It's an unambiguous document. The fight then is over whether this was a reasonable regulation.
That would be the fight, but I think the first question, Your Honor, is whether the authority to enact and adopt reasonable rules and regulations for use includes the power to prohibit.
It might.
It might. The trial court found that it did.
Why wouldn't it, as a matter of law, why couldn't the court say that? For example, you say it's for egress and ingress. If they pass a rule that says you can't leave any of the roadways to leave this community except the paved exit, they can prohibit certain uses of the property, of common areas, right? You can't use the community grills to dry your laundry, right? That's a prohibition.
I would suggest that that is a regulation on how certain common areas could be used, Your Honor. If the POA were to adopt a rule saying this common area cannot be used for drying your laundry, that is a regulation of how it may be used. It's not a prohibition of all use. to answer your question more directly, it is the trial court interpreted section 2.14 as allowing the POA to enact a prohibition of some space. Perhaps that is a reasonable interpretation, but the plaintiff's counter interpretation is also reasonable because it says that 2.14 says that the POA has the authority to adopt a rule for use of the common areas, not for and against use. It doesn't state prohibiting use. So when we look at the language of the contract, and the declaration is a contract between the owners and the association, we have to give the words and phrases their common meaning. And use connotes carrying out an action or purpose. So using a road entails traveling over it from getting to one place to another. So as properly interpreted, section 2.14 permits the association to adopt reasonable rules and regulations for how the owners use the Exit 2 road.
So I'm really confused. Okay. So I thought you were arguing in your brief that your clients had an absolute right to use Road 2. Is that not your argument?
It's not, Your Honor.
Okay.
The right comes from section 2.2.
Oh, let's not get into the 2.2 stuff. I just want to make sure I understand what your argument is. You acknowledge that the board had power to pass reasonable restrictions with respect to the use of the road, right?
Absolutely.
So the only question then before the trial court, and I guess us, were these restrictions reasonable restrictions that, as you characterize it, constitute basically a prohibition on the use of the road?
There's two questions, Your Honor, and let me clarify it. The first question is, does the POA's authority to adopt reasonable rules and restrictions for the common areas include the power to prohibit all use? And then the second question is, if so, is that rule reasonable? Okay? So we're arguing both today. That the first, the trial court interpreted the terms to allow the court to, when it allowed the POA, when it adopts reasonable rules and restrictions, to include the power to prohibit. That's one interpretation. That was the trial court's interpretation. And
Because you're running out of time, I'm going to move you to the second question, because I
Yes.
think
The second-
we've hammered that.
Go ahead.
When you briefed the summary judgment motion, did you ever assert to the court, you can't grant summary judgment because there's a question of fact as to whether this was a reasonable regulation, even if the court's interpretation is the one applied?
We did, Your Honor. In our opposition to the defendant's brief, we stated that issues of reasonableness and good faith are particularly unsuitable for summary judgment. Now, we specifically included that argument within the section of the brief that was addressing a claim that is no longer in the, for the court, which is a claim for breach of fiduciary duty.
Right, but did you ever say, there's a question of fact as to whether this rule is a reasonable rule?
We made that argument with regard to the claim for breach of fiduciary duty. Yes, we did.
Did your opponent, did the board ever come forward? Because remember, this is all on summary judgment. Did your opponent ever come forward and establish under the Celotex line of cases that there was no disputed issue of material fact regarding the reasonableness of the restriction that the board imposed?
I don't believe so, Your Honor. I don't recall if that was something that the defendants argued in their brief. I do know that the trial court, in its opinion, did not address the reasonableness of the rule whatsoever. It implicitly assumed that it was. And that's the fundamental error here, because even if the trial court's interpretation of the declaration is correct, and it is the only reasonable interpretation, again, we don't admit that, but even if it is, there's still this genuine issue of material fact as to whether the POA's rule was reasonable. And that issue of reasonableness is fundamentally unsuited for summary judgment, because an issue of whether a party acted reasonably in adopting a rule or just acted reasonably, period, is almost always left to the trier of fact, which in this case would have been a jury. So that is the error, that even if you don't believe that the plaintiff's interpretation is correct, there's still that issue that summary judgment was not proper, and for that reason, the summary judgment does need to be vacated. At this time, Your Honor, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, my name's Elizabeth Moran. My registration number is 16119. I represent the defendants, the association, and Mr. Scott, who is the president of the association. I'll probably be just referring to them as the association collectively. I had an argument all prepared, but I think the questions are going to be more important in this case. So I'm happy to take any questions at any time. I'm going to try and, I think, address some of the points that the court has made, but do forgive me if I skip around a little bit.
Well, we generally make you do that. So let me start you with,
Okay, I'm ready.
let me start you with the question where we left off. Did your client in the summary judgment motion satisfy its Celotex burden of coming forward to demonstrate a lack of dispute of fact on any one or more of the elements?
Of the breach of contract claim.
Yes. Isn't that all that's left?
Well, yes, that is all that is
Okay.
left. Okay, so I think that requires a bit of an answer here in that on the breach of contract or breach of declaration claim, what the plaintiff was arguing is you can't do this, you can't have this, you cannot impair our rights of ingress and egress, and you can't obstruct the common area in any way. And the trial court dealt with all of those, but what we established is this is what the declarations provide. You know, as to rights to use the common area, they're subject to conditions. The board can adopt reasonable rules and regulations. The obstruction provision doesn't apply to the association. This was all basically a matter of contract construction at this point. Plaintiff never argued in response to that that the declaration was breached because the regulation was not reasonable.
But if you haven't said there's no dispute as to, so you come forward and you say we are entitled to summary judgment because we're allowed under the contract to enact reasonable regulations, and this was a reasonable regulation.
Yes,
You never said the second one, did you?
Well, I think throughout the brief, what was explained was what led up to the enactment finally of this permanent closure. And I would point out, it's very important, this was not a complete closure. It is available for emergency use. So it's not a complete prohibition.
Do you disagree with your opponent's characterization of the regulation that you cannot even use this road to go from house to house within the community?
No, I do disagree with that, and I'm not sure where that comes from because I really do not see that in the briefs. The argument was it's violated because it's gated and it's blocked, and we can't get to exit to
But I'm sorry I interrupted you in response.
Oh, no, I'm sorry.
In response to Judge
okay.
Todd's question. I shouldn't have done that.
Maybe I need a reminder as to where I left
Well,
off. with-
where in the trial court did you place the burden under the Celotex line of cases on your opponent to say there are no disputed issues of material fact regarding the reasonableness of this restriction which the board has imposed? Where did you do that? Where did you say that?
Yes, I think, and without having the briefs in front of me, I can't point you to exactly where, but what we established was, yes, exit 2 road is restricted. You can't use it except for emergencies. Exit 6 road, which is always the main road, is available for use. The trial court specifically found in its order that, you know, not only was the association authorized to regulate vehicle traffic and travel, but it doesn't violate this because all owners still have ingress and egress to their lots and to the public way.
No, but it's not really getting to the point that I'm probably not making very well. But it seems to me, in order for you to get summary judgment, and you won, in order for you to get summary judgment and for you to affirm, for us to affirm that summary judgment, you had to have established two things. Number one, that the board had the right to create reasonable restrictions on the use of the road, number one, and you probably did that. But number two, independent of number one, that the restrictions that were enacted were reasonable. And I just didn't see that in your briefing, And if you didn't meet your summary judgment burden to establish that the restrictions are reasonable, your opponent didn't even have an obligation to respond to that. That's not the way summary judgment works.
Yes, Your Honor, I have to point out, it may have been, things were sort of a little in a different order because these were cross motions for summary judgment, so they were kind of responding to each other. But what we established was, in terms of reasonableness, these things go to reasonableness. It's not completely prohibited. You've got the emergency use. Your ingress and egress is not prohibited. You've got exit 6. If you look at the map and the survey maps and so forth, which were exhibits to all the summary judgment briefings, you can see exit 2 road only really touches 2 lots. I believe it's 17 and 18. From there, it heads on down toward the BNSF right-of-way. So there is no restriction of the ability to get from lot to lot, or, as the trial court found, the ability to get out to the public way to exit 6 to I-25. As was argued in our summary judgment briefs, and the trial court found in its undisputed facts, that when the association had tried other things, to put a combination lock on the gate, to give the combination to all the residents so that they could come and go, unlock it, drive through, lock it back up, it was constantly left open. And there was this security issue. There were numerous reports of people coming in through the BNSF tunnel, coming up, committing theft, breaking into homes, or simply just trespassing without being authorized to be there. That was a real problem. The association had tried to allow the residents to continue to use this road, but the gate was left open, defeating the security purpose.
All of that sounds like a really good argument to make to a jury.
Well, the fact was, I'm sorry.
Why do all of those facts add up to reasonableness as a matter of law that the trial court gets to say at the summary judgment phase?
Because those weren't disputed, and the plaintiffs didn't have anything in response except to say, you can't obstruct a right of a common area. You can't obstruct ingress and egress. They didn't say why it wasn't reasonable. They just said you can't do this. I think that we showed reasonableness. We showed the factors that went into the decision, why it was made, why it is not a complete prohibition, and they did not show anything in return. They cite cases that say reasonableness is generally a question of fact, but that's not necessarily so when the facts are undisputed. I think one of the cases they cite, the bankruptcy estate of Morris, yes, makes that point.
For example, if, as your opponent says, the rule prohibits any traffic on that road, even hundreds of yards short of the gate, wouldn't a jury want to know that and think about whether that is a reasonable restriction?
I'm sorry, I didn't quite catch could you just repeat the question, please?
The way it's characterized today, and I didn't understand this, to be honest with you, before today, it's not just the matter that there's a gate. It's that the rule says you can't use any of this stretch of road. Even drive up to the gate. Like, go watch the sunset from the gate. You can't drive on that road. You're suggesting that it is undisputed, that that's reasonable?
Your Honor, it is not clear to me that that's what the record says about the use of the road.
If it's not clear to you that that's what the record says about the road, aren't we?
Except for emergency music.
I need to stop you.
Sorry, I'm sorry.
If you just said to me, it's not clear from the record what the facts are, don't we need to send this back? How can there be summary judgment if you're acknowledging it's not clear what the facts are?
Oh, I'm sorry, Your Honor. What I meant to say, it's not clear where that argument from the plaintiff came from, that it was you can't even walk or drive down that road to get to the gate. That is not, I think, argued in their briefs, and I am not aware of where in the record there is anything that says you can't. If you want to take a walk, if you want to ride your horse down that road,
Is
if
it
you
what the
want to
rule?
drive your car, although you would have to turn around and come back.
Does the rule clearly say that?
I do not have a recollection. It says that the road is permanently closed except for emergency use.
Well, that's pretty clear. I mean, if it
Yes,
says
I would
the road.
I would just have to defer to What there are a couple of exhibits. There are exhibits to the summary judgment briefs as to the policy that the board enacted.
No, but do you agree that if the rule or regulation enacted said the road is closed, that would support your opponent's construction of the rule? And that does seem to me, as Judge Tao indicated, that does reflect on the reasonableness of the regulation.
Your Honor, again, I would have to say I don't believe that that was argued by the plaintiff, and I don't think that per se a closure of the road where they still have access for ingress and egress and access to everyone else's lot, that is unreasonable or
What
is
would be the purpose? I mean, as I understand, the reason for the gate was people are coming in and doing all sorts of bad things. But if the gate's there and all you got is a road within the community, what's the purpose, what's the rational purpose of closing entirely the road?
It's because it is to discourage intruders, and
Your gate, doesn't the gate do that?
well, it does, but not completely. Somebody could take quite a hike, but that was the way people were getting in. They were coming up and they were taking things. There was a report, it's not discussed in the briefs, but Mr. Scott's deposition is part of the record that was with the summary judgment motion, is that somebody brought presumably a trailer up there and started unloading things from people's houses. So that's the road. So anyway, again, I want to get back to the fact that we teed up the issue of, we have the right to make reasonable regulations, both in our response to plaintiff's summary judgment brief and in our own brief. And plaintiff simply didn't touch that issue. We presented the underlying facts, not a complete prohibition. We have these issues with intruders. You have emergency use. They did not respond. They never argued reasonableness. All they argued was, can't do this at all because it contravenes the declarations or it amounts to a de facto amendment of the declarations, which you can't do without a 51% vote. And by the way, it's an obstruction, and 5.3 says you can't obstruct anything, but as the trial court found, 5.3 applies to owners, not to the association board. So I think by not advancing that argument on summary judgment, the plaintiff has waived it. They did raise it in their breach of fiduciary duty claim, and the court said, I'm going to let that one go. I'm going to deny summary judgment on that, and they dismissed that claim voluntarily with prejudice. They basically walked away from that claim. I'm not quite sure why that happened, but that's what they did. So they had the issue of reasonableness right there, and they did not proceed with it. I am going to let the court ask me whatever additional questions they have. I'm sorry that I jumped around so much, but I did think it was important to answer the questions.
Seeing none, thank you, Counsel.
All right, I would just ask that the court affirm the summary judgment in all respects, both as to the grant of summary judgment to the association and Mr. Scott, and also on the issue relating to production of email documents. Rest on my briefs with respect to that issue. Thank you very much for your time.
Thank you, Your Honors. I will try to be as quick as I can with my time. I think that you're hitting the nail on the head with regard to the burden shifting under Celotex and summary judgment. I don't believe that the defendants, when they moved for summary judgment, demonstrated that there was no dispute of genuine material fact as to whether the rule was reasonable. That was not something that they demonstrated. Secondly, even if they did, as the non-moving party in response to the defendant's party, the plaintiffs argued that the association's actions were not reasonable and that there was a genuine issue of material fact as to whether it was reasonable.
But
So-
you never, I'll tell you from my perspective, the issue of whether the entire roadway was prohibited versus just the fence stopped the use of it, or the gate, wasn't very clearly argued here, let alone below. Did you preserve a claim that you're laying now that we have been prohibited from using any stretch of the road for any purpose, as opposed to, you gated us off, we can't leave through this roadway.
We did, Your Honor. So in the summary judgment briefing, we stated to, and I'm about to
I'm going to let you
expire time.
finish.
We stated to the court that the board, when it enacted its rule, it stated its desire to discontinue any use of the Exit 2 road, and it voted unanimously to permanently close the Exit 2 road beginning May 1st of 2021. Any use. Now, the defendants are stating that there's still open for emergency use, but at most, there's still a genuine issue of material fact about that, because even though they're claiming that there is some emergency use still permitted, that's contradicted by Mr. Scott's actions in changing the lock on the gate, and such that the vast majority can no longer use it, even in the event of an emergency. But ultimately, all this comes down is to a question of reasonableness. So the issue was preserved, and this issue of whether the defendant's actions was reasonable was something that we argued was inappropriate for summary judgment. And because the court did enter summary judgment implicitly concluding that it was reasonable, that is why this court ought to reverse and remand for further proceedings. Thank you, Your Honor.
Thank you. We thank counsel for their arguments. They will be of assistance to us as we resolve this matter. The matter will be deemed submitted, and an opinion will issue in due course.